Hello. I'm going to try and get my eyesight here perfect today, my eye level. I'm attorney Keith Shindler. Thank you for taking the time to view another edition of How to Claim Your Justice. The purpose of these sessions is to try and help educate the viewers and the rest of the Facebook community about personal injury cases, personal injury topics, and how to maximize the value of any personal injury claim. The ultimate goal is to help our clients claim your justice. We welcome positive comments and any questions you may have. To contact us, visit us on the web at www.claimyourjustice.com or call us at 1-888-88-KEITH. That's 1-888-885-3484. Today I'm going to discuss with you representing yourself in a personal injury case. You may think this is a self-serving statement or a topic because, of course, we're personal injury attorneys and I want to represent clients in personal injury cases. However, there's pitfalls to representing yourself. A glaring example would be if you had a fire at your house. I'm not talking about a fire in a frying pan or a fire in an oven, a toaster oven. I'm talking about a real fire. You would call the fire department. Why? Because they're professionally trained, they have the tools that are necessary, and you want to save what is valuable to you. I've had cases over the years where I've had clients over the years who've called and they discuss with me the topic of their case and they're trying to represent themselves. Why are they trying to represent themselves? Is because they don't want to pay an attorney a fee to represent them in the personal injury claim. I generally tell them if it's a very, very minor type of injury and there's not significant dollars at issue, go ahead and try and represent yourself. It's rare that I say that though. I view it as an attorney doesn't cost, it pays. Over the past couple months, I've had two clients, I would say over the past 10 months, I've had two clients call and they were representing themselves. In the first case, the client was very happy that they were able to secure a settlement of a few $1,000s on their own. Sounds great, right? The problem is, my evaluation of the case and the medical bills, the case was worth probably $25,000. Certainly in that situation, having a personal injury attorney represent the client would not have cost, it would have paid because the client would have walked away from the case with significantly more than a few $1,000s. Worse, I had a client call and the client was representing herself, trying to negotiate a settlement herself, and there was a lot of medical records involved, a lot of medical records gathering involved. Yeah, there's a couple different injuries at play, so the client had a specified type of injury that she was suffering and organized what bills go to what type of injury and what the permanency of the injury was valued at. It took out such a long period of time. Sadly, the statute of limitations to file a lawsuit had expired. The client had not successfully negotiated a settlement for herself. Case was essentially dead. So it's not a good idea. It's a real story. And the problem with the second example where the statute of limitations expired is that the client had a significant injury. My guess is the value was in excess of $100,000. And right now the client has zero. So again, the personal injury attorney wouldn't have cost, it would have paid because the client would have been able to get a substantial recovery. Now, there's some issues about how does a personal injury relationship work? Well, it's a contingent fee relationship, and what that means is the attorney fee is contingent on me successfully winning the case. The Claim Your Justice attorneys have to win, and the win is contingent on getting paid. It creates what I would like to describe to clients as a partnership. So the more we're in this partnership together, the more I'm able to recover for my client, the more I'm able to make for our firm, and it's not just self-serving, it's a benefit that pays to the client because I have every incentive to not settle the case for a shorter value or in a shorter period of time to get out of the case and make a quick buck. That's not our goal. Our goal is to maximize the recovery, and it's number one in the client's interest, because the more money I could collect for the client, the more money I earn for the firm, but more importantly, it keeps us in the case together. It's a contingent, it's a win-win relationship. Pitfalls you can suffer when you're trying to negotiate a settlement yourself, some of them are obvious, right? We've already talked about it. You're going to recover significantly less than your case is worth. That's bad. You can't unwind that clock. You can't unring that bell. Once you sign the release document, case is over. You're going to get a check. You're going to be talking to someone along the way afterwards. You're going to say, I had an injury of whatever your injury was, and look at me, I got $7,000, or look at me, I got $5,000. And the person would say, well, I know a little bit about personal injury. I think your case worth $25,000. It's a sad day, but it happens all the time. Who wins in that situation? The insurance company, not the injured party. You could also miss out on recovering what you might need for coverage for future medical services. There might be, let's say you have a scar situation where your injury resulted in a scar, and 6 months or a year or 18 months later, you need a plastic surgery revision to reduce the visibility of the scar. You sign that release, case over. If you didn't include the cost of those future medical services in your settlement, you lose. Sorry. You also have issues of not being able to properly evaluate if there's other insurance coverages that apply. Let's say you're in an accident, and the other side, a car accident, the other side has $25,000 minimum statutory insurance policy, and the insurance company offers that $25,000 for your injury. The problem is, if you don't have experience and knowledge in dealing with this, maybe you forgot to notify your underinsured motorist carrier. Maybe you forgot to see who the owner of the car was to see if it's a company, they have a larger policy. Maybe the company was a loaner and there's a garage policy of the owner, of the dealer owner of the car. You get my point, hopefully. Small issue of lost wages. Let's say you missed a week of work or 2 weeks of work and you didn't get paid from your job. Maybe you don't know that you're supposed to include those lost wages in your claim. Again, insurance company wins, you lose. Another benefit of having a personal injury attorney represent you in a personal injury case is that at the conclusion of the case, we frequently will get involved in negotiating the medical bills. If there's not a sufficient amount of money to cover all the medical bills, there may be a $19,000 hospital bill that we could reduce down to $11,000. It's a big number. These numbers matter. Is that a client right now calling? Excuse me. Last is what I told you in the last example of the caller. You missed the statute of limitations. Bad, bad, bad. You missed that statute of limitations, you get no money, you have no case, and you're left with all your medical bills. It happens, it's real life, and again, insurance company wins, you lose. That's not the goal here at Claim Your Justice. It's to have you win. Remember, if you're injured in any type of accident at work, someone in your family sadly has a wrongful death tragedy, medical malpractice, workers' compensation, call us at Claim Your Justice. That's 188-88-KEITH, 188-88-53484. Have a successful week, and thank you for watching.